Welcome once again to Lehto's Law. Here's Steve Lehto.
Several people sent me a story out of Texas, and it's been widely reported. But somebody went and ordered a home, and the home was being built, custom-built home. And as they got close to moving into custom-built home, the builder backed out and said, we changed our mind. We're going to sell it to somebody else, and we can do that because our contract says we can. So the headline is Fort Worth Family Loses Dream Home. Message for buyers, read the fine print. And the scary part is the fine print in this case is actually quite ominous. And the average person having read it would say, I'm not going to sign that. But the problem, of course, is that when you go to buy a custom-built home, you're going to sign a pile of papers. And this will be simply one clause hidden in there. So if you are in the market for a custom-built home and you're about to sign a contract, look to see if this clause is there, because it could cause you some grief down the road. Gordon Dixon wrote the article. I saw it on Yahoo News, but it's, again, widely reported. A woman named Danielle Ostrowski and her husband were trying to buy a house in the Dallas-Fort Worth expensive housing market. It's the official name for it, the expensive housing market. And she says, watch out for language in the contract. She and her husband, Dan, and their 6-year-old son were planning on moving into a newly built structure, which is a white brick, 4-bedroom, 2,522 square foot home with cathedral ceilings and lots of upgrades in the Spring Ranch neighborhood near US 287 in Willow Springs, far north, Fort Worth. And they've been working on this in their minds for the last 8 months, designing and watching it get built. Those plans were crushed last month, just weeks before they were planning on moving in, when the home builder evoked a little-known clause in the contract that allowed the builder to cancel sale for any reason. The clause is known as a termination for convenience clause, but convenience for them, not for you. And it's a tool in the contract that allows the builder to walk away from the deal, but offers no such escape clause for the buyer. So you can't leave for any reason, but they can. Real estate experts said such language is often included in contracts drawn up by home builders, and that buyers should generally try to avoid signing papers with that language. Danielle asks, where are we supposed to go? Now, the article here says she's an attorney who works in Fort Worth, which makes me wonder how she missed this. But after canceling the contract, the builder then promptly put the home back on the block and asked for more money. So instead of the $416,000 that the Ostrowskis were going to pay, the selling price listed by the builder here was $526,000. So they said, look, we're not going to sell you the house now. We're going to sell it to somebody else, and they're asking $110,000 more for it, which makes you think that could possibly be somehow part of the equation here. The builder denied canceling the contract for those reasons, said it was not because they're trying to take advantage of the soaring real estate market. Meanwhile, home prices are already about 10% higher in that county, and real estate experts forecast that prices will increase roughly another 10% in the coming year. Meanwhile, the owner, or one of the owners of the building company, said the decision to cancel was made after long discussions with several employees who complained that the Ostrowskis were becoming difficult and at times even combative and demanding changes and fixes while the home was being constructed. He said the home was still about 45 days from completion when he canceled the contract. He said, we had every intention of selling this house to the Ostrowskis. 2 weeks ago, we even let them write their name in the concrete driveway. Unfortunately, we had to release them from the contract when it became clear that irreconcilable conflicts and misunderstandings had arisen which could not be resolved in an amicable manner, which sounds a lot like a divorce proceeding. But he said that a combination of factors led to the price increase, including higher building material costs and $30,000 in upgrades that the Ostrowskis had added to the home. The builder also likely will need to make several repairs to the home, including possibly repaving the driveway, which has another family's name in it. Several people with experience in real estate legal matters said prospective homebuyers should watch carefully for language that tilts the contract in favor of the builder. An attorney with the Texas Real Estate Research Center at Texas A&M University named Rusty Adams said it's not uncommon for builders to include a termination for convenience clause in contracts with buyers of newly built homes. But other people said they were surprised by seeing that language. And so the point is, if it's common, it's there, you're going to see it, and the time will come at signing documents that you're going to go, well, I don't like that. Cross it out. If they say no, then you have to understand that they can back out at any time for any reason. And that's such a lopsided thing in a contract that why would you sign that contract? So if you spot that contract, provision, I would say run. A finance and real estate professor at UT Arlington said he has not come across a scenario where a home builder is kicking out a current buyer and putting the home back in the market for a higher price. Well, he has now. He added that a fundamental problem can be created when the home builder draws up the contract, which is common in many instances in which a new neighborhood is being built. The builder can then insert language favoring its position in the agreement, and in many cases, prospective buyers don't read the clauses close enough to realize that they are at risk. So I've seen contracts before, my own that I was signing, or ones that my clients are signing, where there's some weird clause in there that's just crazy. I remember renting an office years and years and years ago, and I had looked at an office in another building, and I liked the office I had looked at, and they prepared a lease and said, here, sign this. And I looked at it and said, we have the right to put you in a different unit. I said, wait, no, I looked at that one. I like that one. And the guy goes, don't worry, we're going to put you there. I said, well, then cross out that clause. And the guy goes, well, it's standard, we can't cross it out. I said, but then that means you have the right to put me. He goes, don't worry, we won't. I go, then cross out the clause. Guy wouldn't cross it out. I didn't rent from him. So even if a prospective buyer objects to including a termination for convenience clause in their contract, the builder can insist on keeping the language. So if the seller refuses to remove the language, the buyer is left with only two choices: accept the risk and sign the deal, or walk away. So this is a bizarre situation. But as the Ostrowskis say, people need to know. And as pointed out, they did etch their names in the freshly poured concrete driveway of what they thought would be their dream home. So the Ostrowski family is now starting over in their quest for a new home and figuring out what to do with the furniture and other trappings they bought for the home. People need to know about this clause in their contract, she said, because what has happened to us is brutal. And apparently they had a home they were in and they sold that home. So right now they're kind of stuck in limbo because they're going to be out of their home without a new place to go. I printed out a copy of the termination for convenience clause so we could talk about this. And again, I'm always curious when people say that they didn't see something or didn't read it or didn't know what it meant. Exactly how convoluted was it? And here we go. It says termination, default, and remedies. So this is a section of a contract. A, termination for convenience. It's the first thing listed. Below that, it says buyer default, and it lists ways that the buyer can default and be held in default to the contract. But the very first termination clause is termination for convenience. And the version I have right here actually shows apparently the initials of the Ostrowskis. So they initialed this clause specifically. Notwithstanding anything herein to the contrary, builder maintains the right to terminate this contract for convenience and without regard, default, or breach. Right there, boom. They can do it without regard, default, or breach, and they can do it for convenience. Goes on to say, in the event of such termination, builder may terminate this contract by providing written notice to buyer, and neither party shall have any further rights, obligations, or liabilities to the other or under this contract. At builder's termination of his contract, builder shall retain the cash deposit described above as liquidated damages. Builder and buyer agree that because of the difficulty in ascertaining the exact damages, the liquidated damages are a reasonable sum, not a penalty, considering the damages builder will sustain in the event that this contract is terminated. Builder reserves the right to convert any termination of his contract into a termination for convenience. So it's kind of interesting that not only can they cancel the contract and sell the house to somebody else, they can cancel the contract and keep any money you gave them and call those liquidated damages. And the question is, if it's being done for convenience, what are your damages? Damages presumably arise from someone's fault, okay? So I think that this clause screams out to you as you're reading it, especially if you're initialing it, that there's a problem here. Notwithstanding anything herein to the contrary, builder maintains the right to terminate this contract for convenience without regard to fault or breach, and in the event of such termination, builder shall retain the cash deposit as liquidated damages. So I'm surprised it doesn't happen more often that they sell the house to somebody, get a deposit, build the house, terminate it for convenience, keep that deposit, and sell the house to somebody else. That deposit is free money at that point. So it's a crazy clause. I've never had a home custom built, so I've personally never seen one of these contracts, and I've not had a client approach me and have me review one. But apparently it's fairly common that that clause is there. It's a question of how often it gets invoked. But I think it's a crazy clause. But I suspect a court would enforce it, and they'd say, well, you read it. It's fairly straightforward. It's plain English. Did you not understand it? The fact that you agreed to it's kind of odd, but, what are you going to do? So it's a crazy situation. But the Fort Worth couple had ordered and were watching built their dream home, and the seller, the builder, decided to back out for convenience and then raise the price in the home for the next buyer. So Fort Worth family loses dream home. Message for buyers, read the fine print. Gordon Dixon wrote it for Yahoo News. Keith, Gayla, and Michael all said it. Thanks a lot. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. An uncontrolled sense of humor is often costly in business.